George, thanks for meeting me this morning to talk me through the changes. I've got friends in England and in Wales who are landlords, so there's a lot of change coming into play now. Talk me through what some of those changes are going to be.
Yeah, you're correct, Sam. So just actually on Friday, the 1st of May, England saw a massive overhaul of its housing legislation. Some of the key headlines stemming from that are Section 21, no-fault notices are being completely abolished. And the extent of that is that where there were previously assured short-hold tenancies, in other words, fixed-term contracts, landlords would set, say, 6 months, 12 months with a tenant. Those have been completely eradicated, so they become open-ended contracts now, so assured periodic tenancies. The result of that is that there are some tenants now who won't be evicted for no reason at all. Landlords have to specify a reason for why they want to recover possession of their property. So it gives tenants an increase in security in their rights.
I'm pretty familiar with the legislation in Wales because it's been in place for a few years, but is there still anything that you think Welsh landlords still need to be wary of?
Yeah, that's a good question. So like you mentioned, in 2022, similar to the current situation now with England, Wales had their overhaul of the legislation. And two things that I would say that are really crucial when it comes to the Welsh legislation is compliance and paperwork. As you may have already experienced as a landlord yourself, there are situations where when you issue an occupation contract to a tenant, you have to then, within 14 days, provide a written statement of occupation contract. And if there's an omission or a problem with that written statement, then that's going to prevent you as a landlord from being able to serve a valid no-fault notice. So whereas England has now abolished it, Wales have continued with the no-fault notice, but they've added more stringent applications to it. So to that extent, they've got a various number of statutory compliant requirements that are required for a landlord to even serve a no-fault notice. That can include, but is not limited to, ensuring your EPC, your energy performance certificate, is in check, your electrical installation conditional report is intact, and so on.
So it sounds like it's England then, which has having the majority of the changes. If you had to really boil it down, what would be the key things if I want to invest in England or I'm the current landlord in England? What are the key things that I need to know?
I think the new legislation is now going to take on a more evidence-based approach because, as I said, with Section 21, landlords not being able to recover possession of property for no reason at all, they're now going to have to stipulate what the reason it is, the grounds upon which they're going to recover that property. And what the new legislation now does is it expands grounds upon which you can recover your property. So the key thing is, in your approach as a landlord, you need to ensure that if you have the intention of recovering a property, you need to follow various evidential steps so that when you go to serve a relevant eviction notice on a tenant, they're aware of the reasons and you can support that.
I actually quite like it. So they basically brought this in to protect the tenants, which I think is actually a good thing. It's to mitigate, I presume, rogue landlords.
Yeah, you're correct. So take, for example, the extra ground now in Section 8 in terms of the landlord wanting to serve a notice with an intention to sell. They can't serve that notice with an intention to sell and then eventually renegade and say, oh, actually, I'm not going to make that sell. They have to take the proper evidence-based steps. And in fact, there will be some penalties if they were to renegade and it turns out that they didn't sell the property and it was a strategic method that they were looking to undertake.
What about rent increases? That's a popular one amongst landlords. How do they deal with that? And is that the same across England and Wales now?
Yeah, so good question. So in England now, it's actually become more tightened and controlled. There used to be multiple avenues upon which you could increase the rent. Whereas now in England, they've restricted it so that you can no longer rely on a rent review clause in a contract. Instead, you would have to serve a particular notice, which was one of the options before, and then give the tenant a period of time upon which they would comply. However, if the tenant considers that your rent increase is too excessive, they would have a right to challenge that in a tribunal. And the tribunal's discretion and view in making any relevant decision, that they would look at the market rent. So as a landlord then, you need to consider, is this rent increase that I'm imposing, is it proportionate? Is it going to be actually fair and equitable to this tenant in question?
I appreciate there's quite a lot of information for landlords to take in here. So where can they go to find out a little bit more?
Yeah, so our commercial litigation team at Harding Evans are specialists in landlord and tenant work, both in England and in Wales. We can help and assist with drafting occupation contracts and also serving eviction notices and possession proceedings. So we are more than happy to help and help every step of the way as well.
Well, thanks, George. I can say wholeheartedly that I've used Harding Evans for some of my probably queries that I'm unsure on to help me as a landlord as well. So yeah, thanks for sharing the knowledge with us this morning. It's going to be so helpful for landlords, I'm sure.
My pleasure. Thank you,
Cheers,
Sam.
George.
Always
Nice
a pleasure.